Right. Good evening and welcome to the second day of the Law of Desire series. We're joined today by Saurabh Kirpal, who is a senior advocate at the Supreme Court. He has appeared in numerous cases, and the most notably being the case that read down Section 377 2018. And he's also written a wonderful book called Sex and the Supreme Court. Saurabh would be joined today by Madhavi Menon, who is the director of Center for Studies in Gender and Sexuality and a professor of English at Ashoka University. Her work on desire has spanned across 2 books, Infinite Variety, and most recently, The Law of Desire, Rulings on Sex and Sexuality in India, which serves as the inspiration for this event. Right, so a quick note on the format. Both speakers will begin with opening remarks, following which there will be a moderated discussion between the two. And finally, we will be taking up questions from the audience. And so if you want to ask any questions to our speakers, please use the Q&A button located in your Zoom screen. We'll try to take as many as we can in the last segment. May I invite you, Madhavi, to begin the conversation?
Thank you, Neil, and thank you for organizing this. And thank you, Saurabh. Such a pleasure, as always, to be in conversation with you, to see you, and to just, to look forward to a scintillating discussion ahead. So I'm delighted to be in this present company, and thank you both for inviting me here. I think we're talking today about, well, I'm sure we'll talk about many things, but I think we're talking today about the question of unnatural desires, right, Neil? I think that's the topic that we had put out there. And as I said, I think our conversation will be wide-ranging, but just a sort of few comments and observations to start us off. The question of what is natural or what is unnatural has a very fundamental relationship to the law, because of course, criminal law is based on the principle of natural justice, which presumes innocence until proven guilty. And so there's a very interesting, and there are very sort of many productive ways in which the law might engage with the idea of something that is natural. What sort of interests me, fascinates me, frightens me, is when those categories of the natural and the unnatural are used in relation to sex within the ambit of the law, or used in relation to desire from the ambit of the law. And I must sort of clarify again that I am not speaking from the perspective of a lawyer. I am not a lawyer. I'm not speaking about it from the perspective of the law. I'm speaking about this and these ideas from the perspective of desire, from the perspective of sexuality, and what looking at the law from such a perspective can tell us about these ideas of the natural and the unnatural. And so if we think about the ways in which laws that talk about desire are premised on an understanding of the natural, we sort of tend to get a picture, and this is something I want us to think about as well, and I want myself to think about more as well, that the use of the word natural, which is very imprecise, it actually covers a lot of things, but the use of the word natural tends to be equated to a certain set of aspirational ideals. And those aspirational ideals tend to be marital, reproductive heterosexuality. And tending towards the sort of masculine side of the heterosexual ambit. So when the law tends to use the word natural, it tends to favor the direction of marital reproductive heterosexuality, which is one of the major reasons it gives me pause when I think about laws that are based on, or laws of desire that are based on this idea of the natural. And so one of the questions I have, of course, is what happens if we get rid of the category of the natural and the unnatural, therefore, altogether? What happens if we reconfigure the ways in which we think about desire legally? And I want to just draw very quickly on 4 quick examples of laws that are premised on this notion of the natural, or this understanding of the natural, which I find sort of deeply, as I said, interesting and problematic. The first, of course, are laws governing transgender people, transgender rights. And as the very term transgender seems to imply, the law considers this realm something that is not part of the natural binary of male and female. And so a lot of back and forth around what to do with transgender laws, transgender bills. The Supreme Court verdict, as we all know, in NALSA in 2014, just a wonderful, wonderful judgment, so progressive and so amazing. But of course, because it talks about what it calls a psychological test of gender rather than the physical test of gender, it sort of sidesteps this idea of the natural, which when the law is passed by Parliament, comes right back in. Because this idea of something being natural or unnatural is very deeply tied with the idea of transgender. And and a particular case that I find fascinating, also the same year as Nalsa, end of 2014, early 2015, is the case of Pinky Pramanik, which many of us might know about, the athlete who was accused by her girlfriend of multiple things, including alleged rape. And the court finally ruled that Pinky, that the rape was never happened or never attempted, because Pinky could not naturally be proven to be a man. And so this idea of what is natural and unnatural affects very many definitions that are premised on gender, including definitions of rape or accusations of rape. And the question of why transgender or why gender should matter in this regard is an interesting question, because Section 375, which governs rape, actually says insertion of any object into the vagina or urethra of a woman. So in fact, you don't necessarily need to own anatomically a sort of male genitalia in order to perform rape. So those were some of the questions that came up around the issue of transgender rights, around the issue of transgender people and cases in that regard, which I find very, very interesting, because the law either sidesteps the idea of the natural, premising it on a binary, or sort of acts conservatively. The second arena that has been interesting legally over the last few years, but which is also premised on a notion of sort of heterosexuality and untrustworthy female sexuality in particular, is the realm of adultery, which, as we know, in Joseph Shine, was overturned by the Supreme Court. And but what is interesting to me about that is that the very existence of adultery laws is always premised on the idea of a woman being adulterous, and in a way that demeans the so-called honor of her husband. And so what seems very interesting to me, and maybe this is so commonplace that we don't even pause to think about it, what seems interesting to me is the idea that the assumption of women's sexual sort of lack of chastity is taken for granted by the law. That there is something about female heterosexuality, forget any other kinds of female sexuality, female heterosexuality that is not trusted and not considered trustworthy. And therefore you had this entire sort of slew of adultery bills premised on that, right? Taking that for granted. And so then you can see how this slides into, say, a realm like menstruation, which is also, and menstruation is a really interesting category for the law to comment on, because if anything, menstruation is the most natural of things, right? It's something that naturally happens to certain bodies. You can't necessarily sort of force it or fake it. And so it's interesting that the menstruating body is considered legally and, of course, socially. Legally and socially, it's considered to be unclean, or sexually dubious, or sexually in need of being kept at arm's length. And I'm thinking, of course, of the famous Sabrimala judgment in 2018, which said, we don't care about custom. That's the word that's used in the Kerala laws that were being challenged. We don't care about custom. You have to allow women, no matter of what age, to enter into Sabrimala through the front steps. Interestingly, it was a 4-1 judgment, and the only judge who dissented in that case was the sole woman judge on the bench. And so you can see how deeply this kind of misogyny is internalized by sort of upholders of the law. And what's interesting is that despite that wonderful judgment, it has pretty much been in abeyance and never, ever carried out. The central government has said it will not support it. The Prime Minister himself has gone on record to say that. And second, a later bench headed by Justice Gogoi said, this is a bigger question. It involves other religions, other places of worship. And so we're going to refer to this to a 7-member bench. And that was the last of that. And so this notion of Imagine a 7-member bench of the Supreme Court sitting in judgment on whether menstruating women should be allowed into a temple. I mean, that seems to me really a sort of fascinating use of this idea of the natural and the unnatural. And the last realm that I want to refer to is, of course, the realm of what we now know as homosexuality, and the celebrated case in this regard, in which Saurabh played such a pivotal role, 377, and again, finally, the verdict, the judgment in 2018 was fantastic and wonderful. But what again fascinates me about the wording of 377 and the judgment is that that is the most open law that talks about this idea of something being natural and unnatural, or natural and against nature. And again, this is something that's never specified. It's most commonly understood to imply reproduction. And so when the law says carnal acts against the order of nature, it is presumed to refer to homosexuality, even though, as I point out, it's really the police and blackmailers who understood it that way. There is absolutely no way you could read that phrase to mean that. But the law is already so biased in the favor of a very, very narrow definition of what is natural, that it sort of ended up criminalizing large sections of our population. And even though 377 was read down, thankfully, and I'm so glad that that happened. What's interesting to me is that that category of the natural and the unnatural, the category of carnal acts against the order of nature, still remains intact in the law. And so it for me, and I'll sort of end with this question and with these thoughts. For me, what's interesting is, does that idea of nature or something natural or something unnatural, does it, well, it does, but should it play any role in the law's thinking about sexuality and desire? Should it actually play any part on the stage in which the law is thinking about or adjudicating what it means, what desires are permitted and what are not, and what would happen if we thought about desire after having removed the category of the natural altogether? So I'll just stop there. And of course, I'd love to return to many of these after hearing Saurabh.
Well, that's fascinating, Madhavi. Whenever you speak, you really do make at least me think, because I'm always waiting for a but in your argument. So you'll make this point, and then comes this little sting in the tail that makes you think about why the law is the way it is. And for you to be a non-lawyer and still make these points, it's interesting. And, COVID has turned all of us into doctors, right? We've all become now semi-doctors. We know exactly what's going on, and we're not just doctors, we're researchers. And I think Madhavi's turned us all into lawyers. Ultimately, the law does affect us all. So it's important that we are aware of it. So the same way we take concern in COVID, I think it's important to recognize and analyze as to what the law does. And one of the things that law does is try to categorize. And it's just the way the law works, right? It has traditionally done so, and that's a method of exercising social control. And that's something I'll come to a bit later. But when you talk of categories of natural and unnatural, that's one of the most peculiar things. And of course, we all say it's came from Section 377, and it was the gift of the British, but we very, very willingly adopted it as a very convenient category of natural and unnatural, because it allows us to exclude the unnatural. And that's something you referred to. No, but what is natural and what is unnatural is I suppose, the sum and substance of any argument in court. To me, I was just reading just shortly before this, a very interesting little tidbit about two male penguins in the New York Zoo who took an egg and managed to hatch it when heterosexual couples failed. And they said they had excellent egg rearing capabilities. That's the little New York Times line that said. So it's obvious that anything that exists in nature is natural, right? So when the law tries to prohibit the unnatural, what is it actually trying to do? Because by mere existence, that is no longer unnatural because it exists, right? So obviously, the law is doing something different than trying to segregate that which is natural and that which is unnatural, because that is a definitional stop, so to say. By very definition, you cannot call it unnatural once it's occurred in nature. And it's also, therefore, it's also very unambiguous and imprecise term. And that is, I think, the problem behind what natural, unnatural is. It is really a case of subjectivity masquerading as objectivity. It's a case of value, I suppose, masquerading as fact. Uh, they just use the words natural and unnatural, and the rest is fill in the blanks, right? That which is now the powerful will decide which is what is natural, and use it as a tool then to suppress that which is they perceive to be unnatural, which is contrary to their interests. So this is a case of the normative really being hijacked in the language of the law as the descriptive, right? So that's something that is very interesting about the use of the word natural, unnatural. Laws are often ambiguous, right? That's standard understanding, because these are words used by Parliament. By the time they come to court, they have multiple meanings. We lawyers argue before judges, and a lot of time is spent on trying to understand the ambiguity of the word. But the word, or the use of the word natural, unnatural, I think has more of a sinister meaning behind it. I think it is aiming to give that which is perceived to be unnatural and a moral, it's trying to give the natural legitimacy and simultaneously, consequently, delegitimize that which is seen to be unnatural. It's a law's way of exercising power and control, right? Ultimately, we shouldn't forget what law is, right? Law is not just some simple thing that has come from just the Vedic traditions and been revealed unto us. No, it is very much a product of society. And it is an attempt by the lawmakers, who are typically powerful men, to frame society into their vision of what society should be. And that is why this term natural, unnatural is a very convenient trope to be used, and to give their version of what their power requires to be natural. So I think that is one way that the law is used. Now, you've given some very interesting examples, Madhavi, of say particularly the adultery judgment. And there I'd ask myself, for instance, when we use the term natural and unnatural, what are we saying? Is adultery natural or not natural? Or is marriage natural or not natural? Now, I would say, and I think you hold this view, that if I have to choose between adultery and marriage, it's clear that it's marriage which is not natural, right? That is an artificial construct which has been made by society for whatever reasons. And you and I may disagree on as to whether it's necessary or not. But the fact is, if there is any construct in this all, it is marriage. And yet we try to conserve the sanctity of marriage through the use of the word terms natural and unnatural, so as to exclude adultery, which is a reflection of sexuality, which is the most natural thing. So everything is turned on its head, really, here in the question of adultery, of that which is natural and that which is unnatural. And what it also does is prioritizes a particular worldview of what a good marriage is, a heterosexual, monogamous relationship, which will always favor the man in the relationship, right? Because that is our view of marriage. We talk of natural and unnatural in terms of adultery, but how about taking something which is very current these days? For instance, there is the Delhi High Court is hearing a clutch of petitions involving marital rape, right? And there is a marital rape exception. Now, are we saying that when the law classifies things as natural and unnatural, and by having the marital rape exception, that it is natural to rape your wife, right? Isn't that also kind of a conception of how we are framing the discourse about marriage? And saying a man can, within the confines of his marriage, rape a woman. And that, of course, shows the power equation between a man and a woman, husband and a wife in our, and this, again, all using the trope of the term natural, right? So I think the term natural is most misunderstood and but most often abused. So I think those are some of my basic beliefs. But coming back to the title of your book, Law and Desire, I have no doubt that law will always attempts to control. It is the function of the law to try to control. But to try to control something as ambiguous and as large as desire, I think this is one case where the laws will eventually fail. Right? You cannot control desire. They will either be struck down by courts or ignored by people. But my only concern is by using these terms and allowing these laws to exist, we permit a lot of pain to carry on. So by the time the law is struck down and desire wins over the law, there will be a lot of broken hearts and a lot of broken souls. So, but it's interesting to, I think, break down what we mean. I read that Nanavati judgment, for instance, that you've also talked about in the chapter of nature and what is natural and what is unnatural. And I particularly like the way you frame the debate as to what is natural. Is it a woman's rampant open sexuality, waiting to sleep with any man she comes across? Is that natural? Because that is also a way of seeing. Or is it a woman's naivety, which we now currently hold in all these views about how to protect women against conversion and love jihad, because a woman is bound to be so easily swayed by the lure of sex that she converts. So these terms are bandied about often, but ultimately we must remember they're moral terms. They're used, they're functional terms put in place by those in power who want to perpetuate their power. That's right. Thanks.
Thank you both for such a wonderful conversation. There's so many multiple threads to unpack. But I have two questions, which I hope can take the conversation forward and complicate the matter a bit more. You both spoke on categories, right? Saurabh, you spoke how categories are there to exercise social control. And Madhavi, in your book, you say that categories are what the law invents to make sense of desire. Now, if we see the Nalta ruling, of course, it's very progressive. It says that self-identified gender can be either male or female or third gender. So it did not really do away with gender as a category to either reject or interpret legal provisions that insist on gender markers in the first place, right? If you also see the trans rules 2020, though it did away with medical intervention, it keeps in place a vetting process to first classify trans persons and then legalize their personhood. So my question is, in between law's intent to protect by nurturing classification, letting it flourish, and its promise to liberate by removing classification or limiting its hold, how do we understand the gaze of the law in our lives, and especially what the law may deem as unnatural lives? And any of you could begin.
Yeah, I think here, just to permit me, Madhavi, to jump in, I think this is a distinction of how I think a lawyer would think and a literary theorist would think, right? I say the law imposes categories because we've been brought up in a legal tradition to think in terms of categories. And judges were once lawyers, and therefore they think like that. And not just judges. You mentioned the category, and law tries to liberate you from categories. Unfortunately, that is not true. The law does not try to liberate us from categories. And in fact, the provision that was most often bandied about, Article 14, which is equality before the law, is precisely about categories. It says you can have categories as long as those categories are legitimate and have some rational nexus with the object sought to be achieved by a particular act. So law will always think in terms of categories because that enables adjudication, that enables deciding who has what power. Whether that's a good thing or a bad thing, I'm not saying. But that's inevitable for how law functions, right? Because we need to put people in the boxes because then we will determine what rights they have. We need to put rights in boxes to have a reverse decision as to who is entitled to those rights. So I don't think we will ever get away from the idea of categories. I think when law tries to liberate, it tries to stuff in as many rights as possible within a particular category. But the idea of the category remains, right? It's a question of what right that category has. Whether that is one way the law deals with it. I suppose Madhavi will say, let's do away with the concept of categories altogether, but that's something I'll let her decide. But in terms of law, and there's something I'd like to discuss with Madhavi about marriage, is I don't think it's so easy to get rid of categories, right? Because they have a functional requirement as well. We need to tick certain boxes for certain reasons, and we'll come back to that. But I think that's my view on what categories and the inevitability in law is concerned.
Yeah, no, I don't disagree at all with you, Saurabh. I don't think we can get rid of categories. But what is fascinating, especially in relation to the Nalsa judgment, Neil, that you brought up, is that the law makes it so abundantly clear that it thinks of gender as an administrative fiction, right? That gender is something that this panel will sit, your gender is something a panel will sit and determine. And if you think about it, that's what happens with every single one of us when we're born. It may not be 4, 5, 6 people. They may have trained one person really well, but that person will determine what your gender is and accordingly enter it in that birth certificate that you have to have before you leave the hospital. So it's fascinating to me to think about how at some level the law knows that the gender on which it is basing its laws and criminalities and rules is a fiction that it itself has invented. And so for me, what is interesting, and again, speaking from the perspective of desire and speaking from the perspective of sexuality, is what happens if we discuss that openly. So instead of that being the secret that everyone knows, but no one is talking about openly, what happens if we talk about that openly and think about gender and therefore desire as an administrative fiction? If it is an administrative fiction, then can we choose which fiction we want to abide by or adhere to, right? And I think we all tell stories about ourselves. We all live narratives out of our lives. How can the law come into being in a way that allows us to choose our narratives based on a principle other than natural or unnatural, right? And what that principle might be, I think is an open conversation, and I would love to have it. But it could be as widespread a principle as just the principle of no harm, right? As long as your narrative does not cause harm to anybody else, you are entitled to your narrative. It doesn't matter what. And then you can have that vetting process and so on and so forth. But this is why, someone like me, who's a professor of English, is so fascinated by the law, is because it is a series of stories that we're telling. The only difference is that the mechanism of the law seems to believe that its stories are somehow true. And that is the point at which the problem arises, right? That is the point at which you are going to go back to what Saurabh so poetically was saying earlier, that's where you break hearts and destroy souls. That's where you sort of tell people, you are this or you are not that, and I have the power to make your life this way or that way. And so there is a way in which the idea of the natural as one of the biggest fictions around, but not recognized as a fiction that is encouraged to forget its own fictionality. That's what interests me about things like the Nalsa judgment.
Just to pick on that, use the word fiction. I think you're right. And one of the biggest fiction that law creates is its own legitimacy. You see, how is law enforced? You can't just police it into existence, because you'll need a police force which is larger than the population of a country. So law typically ensures its legitimacy through the fiction of a moral legitimacy. And in doing that, it needs the concept of natural and unnatural. It needs a concept of morality, because you are basically trying to make people believe that what we're doing is the right thing and therefore you should do it, right? So it's a method of social control which is inevitably based on reliance on people's perception of that which is legitimate or that which is natural. And in doing so, of course, you also impose, as I said, your own morality, but you also need to reflect social morality to some extent. You can't be so divorced from it that the law itself ceases to be illegitimate. And that's when we have revolutions, and that's interesting.
Yeah, no, I agree. One of the epigraphs I have to this book, Saurabh, which you probably saw as well, is from Alfred Kinsey, the sort of famous American sexologist. And he is just fascinating talking about the law. And I won't go into all his arguments here, but what has always been interesting to me is him saying that laws about sex have a separate categorization or separate place in the law from law against, let's say, harm to property or property damage or whatever it is. And this seems to suggest that it has nothing to do, therefore, with protecting people, but it has everything to do with what he calls the practice of protecting custom. That laws about desire have nothing to do with protecting anybody's rights, but have to do with protecting a certain sense of social normativity and social normalcy that then, the entire legal apparatus gets devoted to. And I've always found that idea fascinating.
I think that's absolutely correct. But law is not just about not doing harm to someone. Law is also about entitlements. And that's how law often sees itself, as rights, as to take the concept of marriage, intestate succession, etc. How entitlements to be determined. And it's that when the desire marries law and marries entitlement. That's when there's a toxic combination. Because by giving entitlements to certain naturally preordained categories, which of course are not, you're disentitling those who do not fall within it, right? The way the concept of natural implies unnatural, the concept of entitlement implies necessarily a concept of that which you are not entitled to. And the law is fundamentally concerned with entitlements as well. It's not so you can't just take a harm principle and say allow law to do that. The problem will come, and so it's not going to be so easy as to say let's have the harm principle and have any desire doesn't harm, because that will lessen or take away the law's ability to determine questions of entitlement. Yeah,
and I mean I think we should talk
marriage.
And we should talk about that later, because I think there are other ways in which entitlement could be adjudicated. But yeah, we can get to that.
And okay, since we're talking about marriage and the cat is out of the bag, so there's arguments, right? The marriage as the singular natural order to which our desires must be tethered to. And there's also a theme that is it running through Madhavi's book. How do we sort of make sense of this to marriage as essential to recognizing a preference, such as a preferred partner regardless of sex or gender in equal marriage petitions, and B, marriage as a legal criteria to seek services such as surrogacy and maintenance, both of which excludes cohabiting heterosexual couples, same-sex couples, and trans persons in chosen families or kinships. Any thoughts?
Saurabh, please go ahead.
All right. You see, I believe that marriage is akin to almost like driving on a road, in a manner of speaking, is that while you may have a society of angels, you will always need traffic rules, right? So not everything the law does is normative. Not everything the law does is about prioritizing one gender over the other, one sex over the other. There are certain fundamental rules. And I think marriage and divorcing it from its normative content just now has a very substantial, important portion, which is rule-based, which determines rights of parties, particularly instances where parties have not been able to choose their own rights. So, for instance, as you said, I give the example typically of intestate succession. Supposing there's a cohabiting couple, you're not married, and one partner dies, will the other partner be entitled to receive the entire wealth of that particular person? Now, we can say we don't need marriage to do that. We can have a civil union. We can have this rule as cohabitation. Well, that's all well and good. Now, how will it happen if a person cohabits with 3 people, right? So, and you can say, well, that can be also permitted. You cohabit with 3 people. Then what will happen when you say, well, actually, 2 of those people who hate the third person say, well, the third person wasn't cohabiting, right? So that is why laws have, as I said, these rules which allow you to register the fact that you're a cohabiting person and will have certain rights and entitlements. And that's what I think the function of marriage is, right? I don't believe marriage should be elevated to such a level where it replaces a desire. No, that's no role of marriage. That is no part of what the government should do. But marriage has a very important social and economic function. And I really don't see how we can do away with the idea of marriage or something akin to it, or similar to it. So, for instance, when your loved one is in hospital, you want to go and meet that person. Now, I wouldn't want a stranger to come to me and meet me when I'm in hospital. And how will I show the person who claims to be my cohabiting partner and say, well, there's no requirement for registration. I want to come and see this person. I lived with him. No. So the law requires some kind of pre-registration. And I think if you take the sentimentality out of it, marriage really is a system of pre-registered rules, which should not be applied in a discriminatory manner. And therefore, taking it just as a lump of rules, allow everyone who wants to have it to have that choice. You don't need to necessarily exclude it to monogamous relationship. You could include it to a polyamorous situation, whatever else. But some kind of a registration of a relationship will be necessary. You can call it marriage, rose by any other name, but it'll be necessary. I don't think you can so easily get rid of a concept such as that.
Thanks, Saurabh. Again, I think you and I are in agreement around fundamental issues, one of which is that absolutely, I do not think institutions granting rights should be discriminatory. Absolutely not. And I'm in a complete accordance with that idea, and I strongly stand by it. I also agree with you when you say that it is not going to be so easy to think of a sort of alternative order of being in which marriage could be replaced with another institution or another set of rules or policies. And I think that's also right. But it is our job as thinkers and as activists and as people holding up the mirror to the law or to governance in general or to politics in general, to allow ourselves the imagination to wonder how we might be able to achieve goals X, Y, and Z, currently tethered to institution A, but trying to get it through another institution rather than through institution B. Now, my problem with marriage, and as you know, and we've talked about it so many times, my deep problem with marriage is that it cannot be divorced, as it were. It cannot be divorced from the fact that the government or the state or whatever the authority is approving your choice of romantic sexual partner. And it's only after that approval has been given that all these other rights are then going to accrue to you, whether it is hospital visitation, whether it is inheritance, whether it is whatever it is that those rights are. And for me, I find that so deeply problematic that the government should be the one to put their stamp of approval on who I want to have an intimate relationship with, that I feel there has to be a better way to do this. That is, of course, me thinking about the issue politically. If we think about it historically, there is absolutely no part of the world or no era of history in which marriage has been this happy, joyous thing that has guaranteed equal rights, even, let alone the whole population, to both the partners in that marriage. And so it becomes even more surprising to me when politically, historically, socially, emotionally, sexually, on all these fronts, marriage has not quite worked, why we wouldn't want to give it up and think of an alternative. And so my view on this is that this is a thought experiment that we must all undertake. It'll probably take a long period of time, but we need all the best minds on it, like your own, because we need to be able to say, how do we guarantee rights to everyone, to all, without insisting that anybody needs the approval of the government on the choice of person who they have sex with or not. And so that to me is the big question. And for me, and again, I've said this before, the fact there's already a categorization, let's say, of nationality, right? So the fact of citizenship should guarantee every single citizen every single right that there is to get. Beyond that, maybe this is what it will mean. Maybe it will mean embarking on a universe that is endlessly contractual, right? That you have to then say, A, B, and C are my partners, and they are to get my money when I die, or they are the ones coming. I don't know what it's going to be. I don't think it should be an Aadhaar card version of our lives, but there needs to be some framework that we can think of together that will guarantee us all our rights without separating one person from another on the basis of the legitimacy, quite literally, of their desire or the illegitimacy of it. And so that is my dilemma with marriage. And that is something that I think, I would certainly love to think more about.
I think one way forward could be to hollow out the concept of what it means to be married and make it, if it is almost entirely rule-based as opposed to desire-based, if it is more to do with the law and less with the religion, then I think if we start seeing what marriage is per se, possibly we could organize just another legal status thing. And if we take out the emotional aspect from it, that could be one way forward, I suppose, of how we deal with marriage.
Yeah.
That's what it is.
Yeah.
Thank you. That was amazing. And I think we can take 2 or 3 questions now from the audience, given the time. So the first question is unnatural synonymous to anti-national in present-day jargon? And are there similarities or disparities? Whoever wants to go first can.
I always seem to start first. It's you this time, Madhavi.
Okay. When Saurabh opened his mouth, I thought he was going to start speaking, but he was opening his mouth just to tell me to speak. Yes. Okay, will do. I think that's actually, I laughed when you asked the question, Neil, but I think it is such an appropriate question and such a sort of timely question, as the questioner themselves pointed out. Is unnatural the same as being anti-national? If we look purely in terms of the categories that are bunched together under those 2 terms, there does seem to be, doesn't there, a startling overlap between the 2. And that to me is not curious at all. It's fascinating, but not unexpected. And so if anyone anti-national is, and we all know who it's a growing field, but anti-nationals are, Muslims, Dalits, university professors, transgender people, lower caste women, farmers, lawyers, plenty, social activists, anybody is an anti-national if they do not abide by a certain kind of normative status quo as defined by the powers that be. If we think of the way in which that rhetoric of anti-nationalism gets deployed, it very much is in sync with the rhetoric of the unnatural, because the unnatural is that which is seen as not being in sync with the status quo as defined by the normative powers that be. And so if we think about it that way, and there is this entire additional discourse, Neil, that we've talked about as well so often, of the increasing levels of sort of virulent, violent masculinity that has pervaded the public sphere in the last few years, again, which has been coterminous with the rise of this entire discourse of the anti-national. And so there seems to be a certain kind of North Indian heterosexual male who is considered nationalistic enough and who is considered natural enough. And everybody else, by which I include every single person on the screen right now, for instance, we all fall foul of that definition. We all fall afoul of that categorization. And I think it's very acute and sharp of that questioner to have noticed this idea that actually, even though these might sound like different ideas, they are very much being mapped onto one another in ways that have, it's sort of building a narrative where if you're anti-national, you're also unnatural, you're also non-heterosexual, you're also all these things that deserve to set the state against you.
I mean, there's very little to add, Madhavi, you're so right, because the very concept of what is anti-national is a moral one. The way what is unnatural is a moral one. And I don't think it's a mere coincidence that the very same activities which are seen as unnatural are also anti-national. I think it's implicit in the very concept of anti-nationalism, because what is the converse of anti-national? You're nationalistic, right? And what does it mean to be nationalistic? It means to adhere to the majority philosophy. And what is the majority philosophy? Inevitably that which is natural, because natural is what is being pushed onto us. So these two are married not merely by, as I said, some chance, but these are necessary ways that one sustains the other. As I said, and that is what I alluded to earlier, was that the law is a social tool of social control, the way to put society in check. So it's obvious that nationalism, which is adherence to the law or a perceived notion of what the law of that country is, will tally right with that which the law considers to be natural. So it's an inevitability, and it's well good to call it out. But you've been so eloquent. There's little else for me to add.
Thank you. Next question is, can unnatural move away, or the category of unnatural move away from shame to subversion, which is again like the question asked yesterday, can obscene be an act of protest? So can unnaturalness also be an act of protest?
Well, I think that's earlier. All right, I'll go on this one first. I think this dovetails very neatly into the first question, actually. The moment you tie in anti-nationalism with unnatural acts, if you wish to subvert, you do that which is, see, what is unnatural? It's pretty likely when you are doing an unnatural act, you're out of the bounds of what the majority believes. You've already been pushed to the fringes of society, most likely, right? And through the exercise of whatever the coercive power of the law. And if you are doing that and you're on the fringes of society, doing something society does not want you to do, that is effectively, obviously, subversive of what the mainstream wants you to do. So I think we've answered this really in the earlier question, and it just does follow. Yes, subversive. It is inevitably subversive.
Yeah, I mean, I think that's right, Saurabh, and I agree with you. I do want to pick up a little bit, Neil, on the other term that the question used, which is, can it be rather in the service of subversion rather than of shame? And I think that's a very, very good set of terms to put in conversation with one another, because the association of sex and shame is so deep and is so crippling and debilitating that it is something that we need to take seriously. What might help, and I mean this sort of archly, I don't mean this seriously, I don't think it's helpful, but what might help is to remember, especially in our part of the world, in the sort of entire Indic subcontinent, all sex is considered shameful. And so whether you are heterosexual or not, it is considered shameful to be indulging in sexual activities, right? Or having sex. I mean, you can think back to sort of, heterosexual teenagers wanting to go off with their girlfriends or boyfriends. I mean, never, ever, ever will they be allowed to do that, because this idea is sort of so shameful. And so again, there is this interesting moment of universality here, to think that sex actually is considered shameful, or our legacy, and I do think it's largely a colonial legacy, the legacy of sex that we've inherited is associated with shame. Equally, and this is where, marginalized groups, oppressed groups have been so wonderfully trailblazing in this regard. Equally, what if you take on that shame and say, I'm actually going to own it and flaunt it, rather than sort of saying it's going to cripple me and I'm not going to be able to use it, right? This is an entire debate between gay shame and gay pride, for instance, in the US. And what I've always said in relation to India, the reason why I'm not a big fan of pride parades and the concept of pride is because I feel we have actually so many centuries of history in which shame was not the primary feeling associated with sexual desire. And by elevating the idea of pride as our mark of subversion, we are very much staying within a certain biblical colonialist narrative that says sex is shameful. I don't think the sort of sculptures, the models for the sculptures at Khajuraho were particularly ashamed of their sexual lives, right? I don't think Amir Khusro was particularly shamed by the poetry that he wrote. And so is there some way in which we might be able to sculpt out, as it were, or carve out alternative trajectories in which, rather than shame being the primary association of sex, we make it something else. And it doesn't have to be subversion. It can just be a sort of elation. It can be a campiness. It can be, whatever one wants to think about. But we do have those alternative adjectives, I guess, that we can associate with sex.
Thank you. I think we have time for one more question. And I think this also ties up with some of the thoughts that you both have mentioned. How to destabilize the categorization or compartmentalization of natural or unnatural generated by the law, or how to trouble it, to draw upon Judith Butler's term, troubling gender.
Well, one way would be to make each category so expensive as to render it meaningless, right? If you say everything is natural, then leave the scope for that which is unnatural to be so limited that it ceases to have meaning. That's one way of doing it. So attack the very concept of the category itself. Another way, I suppose, could be, and that is probably ties into the way Madhavi thinks of marriage, is to attribute each of these categories with all the kinds of rights that can possibly be required by a person in any case, right? So as to make it meaningless. There should be no need to create categories. If you take away the normative impact or even the legal impact that a category has by imbuing everybody with the same rights, then whether you call me natural or unnatural, maybe a social impact that it has on me, or a sense of self, my own self. But in the eyes of the law, it will stop having meaning. So if all the rights of a married couple are given to a person living in who are simply cohabiting, then even if you have a class called marriage of someone who's gone and gotten married in a temple or in a registry, and you have, on the other hand, a cohabited couple, it doesn't make any difference, right? So you're destroying this idea of that which is natural or natural by just making it have no legal consequence, right? Because categories have consequences. So I think it'll be easier to tackle consequence than categories, because the law, the way it is framed and is structured and it works, as I said earlier, it's impossible to get rid of categories. You'll not find that easy, both in legal terms as well as in terms of the pushback you will have when you go to court as a practical matter. Yeah. So I think an easier thing to do is to recognize that our constitution is as an egalitarian one and imbues everybody with rights on the status as a citizen. And you start giving people those rights and you render those categories meaningless.
Yeah. I mean, I agree with that. I agree with that, Saurabh. You see, the danger of having moral terms like natural and unnatural be the basis of any kind of law, and I point this out in the book as well, is that you are always then going to need a desire or a category that can be deemed unnatural if you're going to keep that as the basis of the law. Right? So if you're going to have something that's natural, you have to have something to which it is opposed that's going to be unnatural. So there is absolutely no way of guaranteeing fundamental rights to all citizens if you are adjudicating on the basis of natural and unnatural. Because in that regard, you're always going to be saying, in terms of desire, you're always going to be saying this desire is going to be unnatural. And so to my mind, you need to replace that rubric itself. You need to replace that framework itself with, whatever it is that we can think of, a mixture of no harm and entitlements. That's what our conversation has been throwing out and sort of bandying. But I think there is no way that you can retain an adherence or an attachment to the notion of the natural and try to be egalitarian in any way, shape, or form.
Just again, to take up on that, law has two purposes. One is to control, the other is to enable as well. I think we sometimes forget that that is one of the facets of what the law is. It sometimes creates an environment where love can thrive, right? So we lived, you can always say that we had a very egalitarian society prior to the colonialist time, but maybe it wasn't always quite so egalitarian for a large number of castes and sexes and genders. So at that point of time, the law can come in and step in and say, these historical disadvantages are now sought to be removed, right? So the space for desire can be expanded by the law as well. And I think that's maybe something that we should focus on, is a positive impact of the law, rather than just trying to say that law should not control desire. That's true. But law should also create an environment where all kinds of desire is actively enabled and encouraged and promoted. I think that's very important. And some part of that comes right back to the first question, in creating a kind of a country where it's okay to do all this, right?
I mean, I think that's what I understand by the law enabling desire, not necessarily the law sort of listing desires and saying, we'll allow X, Y, Z, A, B, C, all these things, but the law not having any role in that whatsoever. Yes. Which is to say that, and this is why, laws can be enabling and exciting, because when you're doing something that goes against the law, it's an exciting thing. I mean, sexually, it can feel exciting. But there is a way in which that enablement by the law can also go hand in hand with the law sort of stepping back and saying, this is not our domain. Our domain is to, protect against harm. Our domain is to enable the flourishing of people. But our domain is not to register or regulate what X's sexual desire is or might be. And, and to me, that sort of seems like it would be fun.
It's been such a pleasure to listen to you both. And thank you so much for such a wonderful, important, sweet and spicy conversation, for giving us this evening.
Saurabh is sweet and I'm spicy, right? That was
Well, you were the ones who were grading them, so I suppose they'll say you sweet.
Before we say goodbyes, just a quick note. We have announced a giveaway contest for Madhavi's book, The Law of Desire. And the Google form is in the chat. So if you're interested, please fill up the form and we will be selecting 5 winners for a copy of the book. That's all for today's evening. Thank you so much and have a good night.
Thank you. Thanks, Saurabh. Thanks, Neil.
Thanks for having me.